The September session will feature 85 matters, reflecting a notable decrease from the 115 cases heard during the same period last year. As has been the trend in recent years, sexual offences dominate the list, accounting for 34 of the cases. Senior Crown Counsel Howard Pinnock explains.
And the great concern, though, is that of the 34 sexual matters, 21 were committed against children under the age of 16. So that is the great concern. The majority of them are committed against children. 20 homicides, and that includes capital murder, non-capital murder, manslaughter, death by dangerous driving, and 13 non-fatal offences against the person, like dangerous harm, maiming, and grievous harm. So that really is where we're at.
Pinnock also noted fewer criminal cases before the court in the last 5 years.
In September 2020, we had 184 cases. September 2021, it declined to 172. And September 2022, it declined to 136. And September 2023, we went down to 115. So we have had a decrease of 54%, if my maths is correct, within 5 years. And this is a tremendous achievement.
Despite this, serious concerns were raised during the opening of the assizes, particularly regarding the judicial process. Speaking on behalf of the Grenada Bar Association, seasoned criminal defense attorney Anselm Clouden highlighted issues surrounding the amended firearms legislation, which has removed the discretion of magistrates to grant bail for firearm-related offences. Under the current law, only the High Court can grant bail for these cases. He endorsed a suggestion from fellow attorney Jerry Edwin, who has proposed regulations to facilitate speedy bail hearings at the High Court.
What Jerry was saying is there must be a procedure, and we are asking for a procedure whereby when you appear before the magistrate, she can grant bail. Simultaneously, that application is made to the High Court to be heard on that day, because time is of the essence and the Constitution guarantees the liberty of the subject. If it is a bailable offense, then bail ought to be granted, but the judge has the discretion to deny bail. That's the exercise of his discretion, and from which there is no appeal. So that if the act calls for him to then advise the magistrate whether to consider to grant or not grant bail, it means you're looking at 2 or 3 weeks to get before the judge. A normal bail application, it takes 2 weeks, because these are chambers application, and the judge would hear it at his own election.
Clouden also raised concerns about the lack of provisions in the law to address mental health considerations for offenders. He pointed out that judges currently lack the authority to direct mental health offenders to psychiatric institutions as part of their punishment, which results in these individuals being sent to prison, a setting he described as inappropriate for their treatment.
They're not conscious sometimes of the offenses they create because of their mental illness, and therefore sending them to the prison where they're under punitive supervision doesn't assist in a regime of treatment for such persons.
Additionally, Senior High Court Judge Madam Justice Paula Guilford called attention to the absence of legal aid services, urging the government to identify attorneys willing to represent indigent defendants for a small fee. She noted that many times indigent accused persons are not knowledgeable enough to represent themselves, and this puts them at a disadvantage. The September assizes, the last session for 2024, is traditionally the longest of the 3 sittings held annually and features several high-profile cases, including the sentencing of Kieron Chaiton, who is convicted for the January 2020 shooting death of 16-year-old Lenisha Stafford, and Stephen Croney, who faces sentencing for the 2018 shooting death of 36-year-old Kane Isaac Edwards. For GBN News, I'm Nisha Paul.